2. 2. Application includes an application for an original, renewal, duplicate or updated registration, endorsement, commission, or license issued under the Act. 3. Board, the Texas Private Security Board. 4. Department, the Texas Department of Public Safety. 5. Licensee, a company licensed under the Act. 6. Mechanical security device, any device designed to control the opening or closing of a room, building, safe, vault, lockbox, safety deposit box, or motor vehicle, and which is not an electric access control device or alarm system as defined by the Act. 7. Registrant, an individual who holds a registration, endorsement, or commission under the Act. 8. So the State Office of Administrative Hearings. 9. Television camera or still camera system, any device or system of devices that produces a visual image or series of images either recorded, transmitted through an intranet or internet protocol-based device, or monitored by security personnel for the purposes of private security or surveillance. The phrase does not refer to a television camera or still camera system used exclusively a. to monitor traffic conditions on public roads, b. to detect motor vehicle violations on public roads, c. for telephone or video conferencing, d. to monitor a manufacturing process, e. for medical purposes by medical practitioners, f. by a courtroom reporter or videographer to record depositions or testimony, or g. by a licensed private investigator who installs, operates, and maintains ownership of the system for the purposes of an ongoing investigation. Rule Section 35.2 Employment Requirements. A. Those registered with the Department to perform a regulated service may only perform such services for the employer with whom they are registered. A person may not contract to perform a regulated service unless licensed by the Department as a company under Subchapter F of the Act. B. The employment relationship between a licensed company and its registered or commissioned employees must be such that the licensee's commercial liability insurance policy provides the statutorily required coverage for claims arising from the regulated services provided on behalf of the licensee by its registered or commissioned employees. The failure to maintain and provide current documentation of such coverage is a violation of the Act. Rule Section 35.3 Registration Applicant Pre-Employment Check. A. Pursuant to Section 1702.230 of the Act, the pre-employment background check of the applicant, described in subsection C of this section, must be conducted when 1. An application meeting the requirements of Section 35.21 of this title, relating to registration applications, has been submitted. 2. The Department's website does not indicate the application is complete within 48 hours after the submission of the applicant's fingerprints, and 3. Regulated services are to be performed by the applicant prior to issuance of the registration. B. The ability to perform a non-commissioned regulated service prior to licensure is conditional on either 1. Department notification that a complete application has been received and a. performance of the pre-employment background check required under subsection C of this section. B. The determination that the applicant is not disqualified based on the background check, and c. the employer's retention of the search results in the employee's file, as required by subsection E of this section, or 2. The absence of notification by the Department that a complete application has been 5. received, the passage of 48 hours since submission of the application materials required by Section 35.21 of this title, relating to registration applications, and a. performance of the pre-employment background check required under subsection D of this section. B. The determination that the applicant is not disqualified based on the background check, and c. the employer's retention of the search results in the employee's file, as required by subsection E of this section. C. For purposes of B1 of this section, the pre-employment background check must at a minimum include the review of either the Department's publicly accessible criminal history website or a commercial criminal history website, review of the department's sex offender registry website, and confirmation the applicant is not disqualified for the registration or endorsement based on either the applicant's criminal history or the requirement to register as a sex offender under Chapter 62, Code of Criminal Procedure. Nothing in this subsection precludes an employer from using a more stringent method of determining an applicant's eligibility. D. The employer must maintain written documentation of the pre-employment check for at least 2 years, regardless of the subsequent employment status of the applicant. The absence of such documentation constitutes a rebuttable presumption that the background check was not conducted. Rule Section 35.4 Guidelines for disqualifying criminal offenses. A. The private security industry is in a position of trust. It provides services to members of the public that involve access to confidential information, to private property, and to the more vulnerable and defenseless persons within our society. By virtue of their licenses, security professionals are provided with greater opportunities to engage in fraud, theft, or related property crimes. In addition, licensure provides those predisposed to commit assaultive or sexual crimes with greater opportunities to engage in such conduct and to escape detection or prosecution. B. Therefore, the Board has determined that offenses of the following types directly relate to the duties and responsibilities of those who are licensed under the Act. Such offenses include crimes under the laws of another state or the United States, if the offense contains elements that are substantially similar to the elements of an offense under the laws of this state. Such offenses also include those in quat, aggravated and quat, or otherwise enhanced versions of the listed offenses. C. The list of offenses in this subsection is intended to provide guidance only and is not exhaustive of either the offenses that may relate to a particular regulated occupation or of those that are independently disqualifying under Texas Occupations Code, Section 53.021a.2.4. The listed offenses are general categories that include all specific offenses within the corresponding chapter of the Texas Penal Code. In addition, after due consideration of the circumstances of the criminal act and its relationship to the position of trust involved in the particular licensed occupation, the Board may find that an offense not described below also renders a person unfit to hold a license. In particular, an offense that is committed in one's capacity as a registrant under the Act, or an offense that is facilitated by one's registration, endorsement, or commission under the Act, will be considered related to the licensed occupation, and may render the person unfit to hold the license. 1. Arson, damage to property, any offense under the Texas Penal Code, Chapter 28. 2. Assault, any offense under the Texas Penal Code, Chapter 22. 3. Bribery, any offense under the Texas Penal Code, Chapter 36. 4. Burglary and criminal trespass, any offense under the Texas Penal Code, Chapter 30. 5. Criminal homicide, any offense under the Texas Penal Code, Chapter 19. 6. Disorderly conduct, any offense under the Texas Penal Code, Chapter 42. 7. Fraud, any offense under the Texas Penal Code, Chapter 32. 8. Kidnapping, any offense under the Texas Penal Code, Chapter 20. 9. Obstructing governmental operation, any offense under the Texas Penal Code, Chapter 38. 10. Perjury, any offense under the Texas Penal Code, Chapter 37. 11. Robbery, any offense under the Texas Penal Code, Chapter 29. 12. Sexual offenses, any under the Texas Penal Code, Chapter 21. 13. Theft, any offense under the Texas Penal Code, Chapter 31. 14. In addition, a. An attempt to commit a crime listed in this subsection. B. Aiding and abetting in the commission of a crime listed in this subsection, and 6. C. Being an accessory, before or after the fact, to a crime listed in this subsection. D. A felony conviction for an offense listed in subsection C of this section is disqualifying for 10 years from the date of the completion of the sentence, unless subject to this subsection. A Class A misdemeanor conviction for an offense listed in subsection C of this section is disqualifying for 5 years from the date of completion of the sentence. F. Conviction for a felony or Class A offense that does not relate to the occupation for which license is sought is disqualifying for 5 years from the date of commission, pursuant to Texas Occupations Code, Section 53.021A2. G. Independently of whether the offense is otherwise described or listed in subsection C of this section. A conviction for an offense listed in Texas Code of Criminal Procedure, Article 42.12, Section 3 grams, or Article 42A.054, or that is a sexually violent offense as defined by Texas Code of Criminal Procedure, Article 62.001, or a conviction for burglary of a habitation, is permanently disqualifying, subject to the requirements of Texas Occupations Code, Chapter 53. H. A Class B misdemeanor conviction for an offense listed in subsection C of this section is disqualifying for 5 years from the date of conviction. I. Any unlisted offense that is substantially similar in elements to an offense listed in subsection C of this section is disqualifying in the same manner as the corresponding listed offense. J. A pending Class B misdemeanor charged by information for an offense listed in subsection C of this section is grounds for summary suspension. K. Any pending Class A misdemeanor charged by information or pending felony charged by indictment is grounds for summary suspension. L. In determining the fitness to perform the duties and discharge the responsibilities of the licensed occupation of a person against whom disqualifying charges have been filed or who has been convicted of a disqualifying offense, the board shall consider 1. The extent and nature of the person's past criminal activity. 2. The age of the person when the crime was committed. 3. The amount of time that has elapsed since the person's last criminal activity. 4. The conduct and work activity of the person before and after the criminal activity. 5. Evidence of the person's rehabilitation or rehabilitative effort while incarcerated or after release. 6. The date the person will be eligible. And 7. Any other evidence of the person's fitness, including letters of recommendation from a. prosecutors or law enforcement and correctional officers who prosecuted, arrested, or had custodial responsibility for the person, or b. the sheriff or chief of police in the community where the person resides. M. In addition to the documentation listed in subsection L of this section, the applicant or licensee or registrant shall furnish proof in the form required by the department that the person has 1. Maintained a record of steady employment. 2. Supported the applicant's dependents. 3. Maintained a record of good conduct. And 4. Paid all outstanding court costs, supervision fees, fines and restitution ordered in any criminal case in which the applicant has been charged or convicted. N. The failure to timely provide the information listed in subsection L and subsection M of this section may result in the proposed action being taken against the application or license. O. The provisions of this section are authorized by the Act, Section 1702.004b, and are intended to comply with the requirements of Texas Occupations Code, Chapter 53, Rule Section 35.5 Standards of Conduct. A. The State Seal of Texas may not be displayed as part of a uniform or identification card, or markings on a motor vehicle, other than such items prepared or issued by the department. B. Licensees and registrants shall cooperate fully with any investigation conducted by the department, including but not limited to the provision of employee records upon request by the department and compliance with any subpoena issued by the department. C. If arrested, charged, or indicted for a criminal offense above the level of Class C misdemeanor, a registrant shall within 72 hours notify the employer, and the employer, when notified by the employee or otherwise informed, shall notify the department in writing, including by email, within 72 hours of notification. The notification shall include the name of the arresting agency, the offense, court, and cause number of the charge or indictment. The registrant and employer must supplement their respective notifications as further information becomes available. 7. D. Any registrant who has been issued a pocket card shall carry the pocket card on or about his person while on duty and shall present same upon request from a peace officer or to a representative of the department. Rule Section 35.6 Contract and Notification Requirements. A licensee shall inform the client of the right to a written contract describing the fees to be charged and the services to be rendered. B. If requested, a written contract for regulated services shall be furnished to a client within 7 days. C. The written contract shall be dated and signed by the owner, manager, or other individual expressly authorized to execute contracts on behalf of the licensee. D. Within 7 days of contracting for regulated services with another licensee, the licensee shall 1. Notify the recipient of those services of the name, address, and telephone number, and individual to contact of the company that purchased the contract. 2. Notify the recipient of services at the time the contract is negotiated that another licensed company may provide any, all or part of the services requested by subcontracting or outsourcing those services, and 3. Notify the recipient of services of the name, address, phone number, and license number of the company providing those services, if any of the services are subcontracted or outsourced to a licensed third party. E. The notice required under subsection D of this section shall 1. Be mailed to the recipient in a written form that emphasizes the required information, and 2. If the services are those of an alarm system company, required notice shall include stickers or other materials to be affixed to the alarm system indicating the alarm system company's or alarm system's monitor's new telephone number. F. Subsection E of this section shall not apply to an alarm system company that subcontracts its monitoring services to another alarm system company if the conditions detailed in this subsection are met. 1. The contract for monitoring is with another alarm systems company licensed under the Act. 2. The contract between the original contracting licensee and the client remains in full force and effect, continues to govern all rights of the client with respect to the provision of alarm services, and remains in the control of the original contracting licensee. 3. Neither the contact information provided to the client, nor the address and telephone numbers for alarm service, have changed as a result of the subcontracting arrangement, and 4. The contact information provided to the client relating to the monitoring of the alarm system has not changed. Rule Section 35.7 Firearm Standards. A. Commissioned security officers and personal protection officers may only carry a firearm of the category with which they have been formally trained as required under the Act in this chapter, and for which documentation of the training is on file with the Department. B. The recognized firearm categories are 1. SA any handgun, whether semi-automatic or not. 2. NSA handguns that are not semi-automatic, and 3. STG shotgun. C. Commissioned security officers and personal protection officers must exercise care and sound judgment in the use and storage of their firearms. D. A security officer may carry an inoperative, unsafe, replica, or simulated firearm in the course and scope of employment or while in uniform. E. A commissioned security officer or personal protection officer may brandish, point, exhibit, or otherwise display a firearm at any time, except as authorized by law. F. A discharge of a firearm by a security officer while on duty or otherwise acting or purporting to act under the authority of a security officer commissioned shall be immediately reported to the officer's employer. The employer must notify the department of the discharge of a firearm in writing within 24 hours of the incident. The notification to the department must include 1. The name of the person discharging the firearm. 2. The name of the employer. 8. 3. The location of the incident. 4. A brief description of the incident. 5. A statement reflecting whether death, personal injury, or property damage resulted. And 6. The name of the investigating or arresting law enforcement agency, if applicable. Rule Section 35.8 Consumer Information and Signage. A licensee shall, either orally or in writing, notify all clients or recipients of services of the license number and the mailing address, telephone number, and email address of the Department's Regulatory Services Division for the purpose of directing complaints. B. If a licensee chooses to provide the notice required by subsection A of this section in written form, the notice shall contain the company's license number and mailing address, telephone number, and email address of the department, in a typeface of the same size as that which appears in the document as a whole, but in no case less than 10-point font. C. All licensees must display conspicuously in the principal place of business and in any branch office a sign containing the name, mailing address, telephone number, and email address of the Department's Regulatory Services Division, and a statement informing consumers or recipients of services that complaints against licensees may be directed to the department. D. The company's license number must be displayed on any vehicle on which the company name is displayed, and must be in letters and numbers at least 1 inch high and permanently affixed, or magnetically attached to each side of the vehicle in a color contrasting with the background color. Rule Section 35.9 Advertisements. A licensee's advertisements must include 1. The company name and address as it appears in the records of the department, and 2. The company's license number. B. No licensee shall use the Texas state seal or the insignia of the department to advertise or publicize a commercial undertaking, or otherwise violate Texas Business and Commerce Code, Section 17.08, or Texas Government Code, Section 411.017. C. The use of the department's name is prohibited when it may give a reasonable person the impression that the department issued the statement or that the individual is acting on behalf of the department. D. For purposes of this section, an advertisement includes any media created or used for the purpose of promoting the regulated business of the licensee. Rule Section 35.10 Residential Solicitation. A licensee or employee of a licensee who offers or attempts to sell regulated goods or services to a homeowner or resident of a home or apartment through direct physical contact, including door-to-door solicitation, shall 1. Carry a department-issued pocket card, or a receipt of registration issued by the department, and present said pocket card or proof of registration for inspection to the homeowner or resident. 2. Inform the homeowner or resident of the person's name and employer's name. 3. Provide to the homeowner or resident, at no charge, a document or business card listing the person's name, employer's name, address, phone number, license number, and the department's phone number with instructions on how to contact or file a complaint with the department. 4. Not approach or solicit a home or residence during any times where a placard is displayed indicating that the homeowner or residential occupant does not wish to be solicited. And 5. Provide to the local law enforcement agency with primary jurisdiction a written list of all registrants that will be engaging in the door-to-door solicitation of its residents before any solicitation occurs. The licensed company shall update the information provided to the above referenced agency if there are any changes to the list. This notification can be made via fax, email, regular mail, or by hand delivery to the agency. This notification shall include the company name and department issued license number. Rule Section 35.11 Guard Dog Welfare Requirements. Each guard dog company and any licensed company using guard dogs shall comply with the requirements. 9. Detailed in this section. 1. All pens, spaces, rooms, runs, cages, compartments, or hutches where guard dogs are housed, exercised, trained, or placed shall be kept clean and maintained in a sanitary condition. Excreta shall be removed as often as necessary to prevent contamination of the inhabitants and reduce disease hazards and odors. Adequate shelter shall be provided to protect animals from any form of overheating or cold or inclement weather. 2. All animals shall be fed at least once a day except as otherwise might be directed by a licensed veterinarian. The food shall be free from contamination, wholesome, palatable, and of sufficient quality and nutritive value to meet the normal daily requirements for the condition and size of the animal. Food receptacles shall be accessible to all animals and shall be located so as to minimize contamination by excreta. Feeding pans shall be durable and kept clean and sanitary. Disposable food receptacles may be used but must be discarded after each feeding. Self-feeders may be used for the feeding of food and shall be kept clean and sanitary to prevent molding, deterioration, or caking of feed. 3. All animals shall be furnished ample water. If potable water is not accessible to the animals at all times, it shall be offered to them at least twice daily for periods of not less than 1 hour, except as directed by a licensed veterinarian. Watering receptacles shall be kept clean and sanitary. 4. All animals shall be vaccinated by a licensed veterinarian against rabies by the time they are 4 months of age and within each subsequent 12-month interval thereafter. Official rabies vaccination certificates issued by the vaccinating veterinarian shall contain certain standard information as designated by the Department of State Health Services. Information required is detailed in this paragraph. A. Owner's name, address, and telephone number. B. Animal identification, including species, sex, age 3 month to 12 month or older, size, pounds, predominant breed and colors. C. Vaccine used, producer, expiration date, and serial number. D. Date vaccinated. E. Rabies tag number, and F. Veterinarian's signature and license number. Rule Section 35.12 Classification of Electronic Access Control Device. Company License. Pursuant to the Act, the Department has established that the Electronic Access Control Device Company license will be classified as a Class B, Security Services Contractor License. Rule Section 35.13 Drug-Free Workplace Policy. A. In the interest of creating a safe and drug-free work environment for clients and employees, all licensed companies shall establish and implement a drug-free workplace policy consistent with the Texas Workforce Commission's and Quat, Drug-Free Workplace Policy. B. A copy of the company's drug-free workplace policy shall be signed by each employee and kept in each employee's file. Rule Section 35.14 Security Officer Uniforms. A. All commissioned and non-commissioned private security officers shall, at a minimum, display on their outermost garment the name of the company by which the security officer is employed, the word and quat, security, and quat, and the last name of the security officer. These items shall each be of a size, style, shape, design, and type that are clearly visible by a reasonable person under normal conditions. B. Subsection A of this section does not apply to a personal protection officer while performing personal protection services in plain clothes. Subchapter B. Registration and licensing. Rule Section 35.21 Registration applications. A. It is the responsibility of the licensed company to ensure an application that meets the requirements of this section has been submitted to the department by or on behalf of any employee who is required to register under the Act. An application must include all items 10 required under subsection B of this section in order to comply with the requirements of Section 1702.230c of the Act. B. The items detailed in this subsection must be submitted in the manner prescribed by the Department, prior to employment in a regulated capacity. 1. The required fee. 2. A copy of the applicant's Level 2 certificate of completion when applicable. 3. Fingerprints in the form and manner approved by the Department. And 4. The criminal history check fee is provided in this chapter. C. As part of the Department's criminal history check, additional court documents or related materials may be requested of the applicant. Failure to comply with such a request may result in the rejection of the application as incomplete. Rule Section 35.22 Renewal applications for registrations and licenses. A. An application for renewal must be submitted in the manner prescribed by the Department. The application must include 1. The required fee, 2. Fingerprints in the form and manner approved by the Department, and 3. The criminal history check fee as provided in this chapter. B. A complete renewal application must be submitted prior to expiration for the current registration, endorsement or license to remain in effect pending the approval of the renewal application. If the completed application is not received by the Department prior to the expiration date, no regulated services may be performed until a complete renewal application is submitted in compliance with this chapter. Rule Section 35.23 Termination of incomplete applications. A. If an application is illegible or incomplete, the Department will notify the applicant of the deficiency. The applicant will have 90 days from the date of notice to address the deficiency. Upon request of the applicant, the Department may extend the period to address the deficiency for one additional 90-day period. If the applicant is unable to provide the required information, the applicant may request a hearing before the Department to determine whether the application may proceed without the requested information. If the applicant has neither provided the required information nor requested a hearing prior to the expiration of the time allowed for compliance, the application will be terminated. An application will not be terminated while a hearing requested under this subsection is pending. B. If an applicant fails to provide all required application materials, or fails to respond to a request by the Department for additional information necessary to process the application will be terminated under the process set out in subsection A of this section. C. Following the termination of an application, a new application must be submitted. Rule Section 35.24 Photographs. If the applicant does not have a digital photograph on file with the Department or the Department is unable to access the photograph on file, the laminated pocket card will be issued without a photograph. When presenting such a pocket card to a peace officer or to a representative of the Department, the registrant shall also present a valid government-issued identification card or driver's license. Rule Section 35.25 Assumed names, corporations. A. All individual applicants doing business under an assumed name shall submit an assumed name certificate from the county clerk of the county in which the applicant either 1. Has or will maintain business or professional premises, or 2. Conducts business or renders a professional service, if the person does not or will not maintain business or professional premises in any county. A. Corporations and other entities permitted and governed by the Texas Business Organizations Code using an assumed name shall submit an assumed name certificate from the Texas Secretary of State and the county clerk of the county in which the entity either 1. Has or will maintain business or professional premises, or 2. Conducts business or renders a professional service, if the entity does not or will not maintain business or professional premises in any county. B. Corporate applicants shall submit a current certificate of existence or a certificate of authority from the Texas Secretary of State. C. Licensees may not operate under any name not reflected in current department records as the 11. name under which the licensee will be doing business. Rule Section 35.26 Reclassification and Assignment. B. When a Class A or B license is reclassified as a Class C license, a fee in the amount of the difference in the cost of the licenses shall be paid. There shall be no refund when a Class C license is reclassified as a Class A or Class B license. C. The Department may approve the assignment of a company license to the spouse or heirs of a deceased owner provided 1. A copy of the owner's death certificate is filed with the Department. 2. A copy of the will, order admitting will to probate, letters of testament, affidavit of heirship with 2 affiant signatures, or order of heirship is filed with the Department. And 3. In the case of the death of a qualified manager, that a replacement manager is qualified within 90 days. D. Other assignments will be permitted only where the majority owners of the original licensee Maintain majority ownership of the proposed assignee. The assigner must provide the department written documentation establishing the intended date of assignment, and must ensure any new owners required to register have been approved by the department. The assignee may not perform regulated services prior to the proposed date of assignment or the date of the department's approval of all required registration applications for new owners, whichever is later. An additional assignment fee will be assessed as provided by this chapter upon assignment of a license under subsection B or C of this section. Rule Section 35.27 Insurance. To comply with the Act's requirements relating to documentary evidence of insurance coverage, the documents submitted to the department must specifically show 1. That the insurance is applicable to the conduct for which the licensee is licensed. 2. The exclusions or endorsements specific to the activity for which the licensee is licensed, or that there are no such exclusions or endorsements, and 3. The statutory minimum coverage limits, specifically distinguishing the limits for A. Each occurrence of bodily injury and property damage, B. Each occurrence of personal injury, and C. The total aggregate amount of coverage for all occurrences. B. The applicant or licensee must also provide the department with the insurance agent's current contact information and Texas license number. C. Proof of insurance must be submitted in a form and manner prescribed by the department. D. Pursuant to the Act, failure to maintain on file with the department evidence of current insurance coverage as required under this chapter will result in immediate suspension of the license. The suspension will become effective upon receipt of the notice. The suspension may be rescinded upon receipt by the department of proof that there was no lapse in coverage. Such proof must be submitted within 10 business days following the effective date of the suspension. In the event of a lapse in coverage, or the failure to provide evidence of continuous coverage, within 10 business days, the license will not be reinstated until a complete application for reinstatement is submitted and approved. The application may be denied on grounds that the licensee has violated the Act or this chapter, including having provided regulated services, while suspended pursuant to the Act. Rule Section 35.28 Registrant name change. A change of name must be reported to the department within 30 days of the effective date of change. The notice of the change shall be in writing, and shall include a certified copy of the legal document ordering the name change. Rule Section 35.29 Registrant termination. When a registered employee of a licensee is terminated for any conduct in violation of the Act or this chapter, the licensee shall notify the department of such conduct within 14 days of termination. The notification shall be submitted in the manner prescribed by the department and must include any and all available documentation or evidence concerning the alleged offense. 12. Subchapter C Manager Standards. Rule Section 35.41 Manager Standards. A qualified manager shall not knowingly allow or direct any person under their control to violate a provision of the Act, this chapter, or any criminal statute. B. For purposes of the supervision required under the Act, a manager must have continuous oversight of no more than 3 companies and 2 schools, the supervised individuals, or their intermediate level supervisors, in a manner sufficient to ensure that all supervised individuals are in compliance with the Act and this chapter. 13. Rule Section 35.42 Manager Examination. All applicants for registration as qualified manager of a licensee must pass the written examination administered by the department. All applicants must pass the examination with a minimum score of 70%. B. Good order and discipline will be maintained during the examination. Conduct which is disruptive is grounds for immediate removal. C. An oral examination may be given upon receipt of proof of dyslexia as defined by Texas Education Code, Section 51.970. Proof must be submitted in writing in a manner prescribed by the department. D. Any examination other than the single examination authorized by payment of the original license fee shall be considered a re-examination for which the re-examination fee shall be required. Rule Section 35.43 Operation without manager. A. When a qualified manager of a licensee has been terminated or is no longer employed as manager and the department has been notified of the action in writing within 14 days, a business may be temporarily operated by an owner, officer, partner, or shareholder for a period not to exceed 60 days following the date of the manager's termination or cessation of managerial duties. B. In the event summary action has been taken against the manager must immediately cease all regulated functions as qualified manager. Any applicable period of temporary operation pursuant to subsection A of this section shall run from the effective date of the summary action. Subchapter D. Disciplinary actions. Rule Section 35.51 Complaints. Complaints relating to alleged violations of the Act or this chapter should be submitted in writing to Department Headquarters through the Private Security Program's website or mail to the Department's Regulatory Services Division. The complaint should provide 1. Name and contact information of complainant. 2. Name and type of business of licensee. 3. Specific dates and times of described events. And 4. Detailed description of the violation. Rule Section 35.52 Administrative penalties. The administrative penalties in this section are guidelines to be used in enforcement proceedings under the Act. The fines are to be construed as maximum penalties only, and are subject to application of the factors provided in Section 1702.402 of the Act. Violation description fine amount. UNI-uniform violation failure to display last name identification on outermost garment. $25. UNI-uniform violation. Failure to display the word security on outermost garment. $50. UNI-uniform violation. Failure to display company name on outermost garment. $50. FPPC. Failure to present pocket card. Failure to present pocket card upon request. Failure to present valid government issued photo ID if no photo on card. $100. 14. RICF. Employee records. Violation. Full name of employee. $25. RICF. Employee records. Violation. Position of employee. $25. RICF. Employee records. Violation. Current residence of the security officer as reported by security officer. $25. RICF. Employee records. Violation. Date of employment when performing a regulated service. $25. RICF. Employee records. Violation. Address of employee as reported by employee. $25. RICF. Employee records. Violation. Social Security number. $25. RICF. Employee records. Violation. Last date of employment. $25. RICF. Employee records. Violation. Date of birth. $25. RICF. Employee records. Violation. Place of birth. $25. RICF. Employee records. Violation. One color photograph. $25. RICF. Employee records. Violation. Failure to keep employee records. 2 years. From termination. $100. RICF. Employee records. Violation. Commission only. Current duty assignment and location. $50. RICF. Employee records. Violation. Signed copy of drug-free workplace policy. $25. DNP no drug policy. Failure to establish drug-free workplace policy. $100 per quarter. OPSL-operating while license. Suspended operating with a suspended license. $500 every 14 days. OPAL. Operating while license. Expired operating with an expired license. $500 every 14 days. Registration violation. Failure to comply with registration application. Requirements prior to regulated employment. $200 every 14 14 days. Registration violation. Ineligible. Enhancement to above violation, REG, 4. Employing ineligible individual, $200. Additional, 15. Address change, violation. Failure to notify the department within 14 days of change of address, $350. Con, other contract violation. Licensee failure to provide written report within 7 days, $500. DISP, consumer sign violation. Failure to display the consumer sign in a prominent place, $100. Post, failure to post license. Failure to post the license, $100. Adverb, advertising violation. Failure to have company name as stated in department records, $100. Adverb, advertising violation. Failure to have company address as stated in department records, $100. Adverb, advertising violation. Failure to display license number as issued by the department, $100. Adverb, advertising violation. Misrepresentation, deceptive or fraudulent advertisement, $500. BRNC, failure to notify establishment of branch office. Failure to notify department within 14 days of opening branch office, $500. BRNT, failure to notify closing of branch office. Failure to notify department within 14 days of closing of branch office, $350. CHNG, failure to notify department of change of license, name. Failure to notify department of a change in business name, $500. MGRQ, failure to qualify a manager. Failure to qualify a manager within 60 days, $500 every 14 days. MGRS, manager failing to control business. Manager failing to maintain adequate supervision, $3,000. MGRT, failure to notify department of manager termination within 14 days. Failure to notify department of manager termination within 14 days, $500. OPS- failure to notify department of a change of ownership. Failure to notify change of ownership within 14 days, $500 every 14 days. Seal, using state seal or DPS seal. Improper use of state seal of Texas or insignia of the Department of Public Safety, $500. APINS, operational insurance violation. Operating without insurance, or outside scope of coverage, $500 every 14 days. 16. INSD-insurance, documentation violation. Failure to comply with requirements relating to proof of insurance, $500. RICF, employee records violation. Failure to conduct pre-employment check, $500. ZREC training, CE school records violation. Failure to maintain required records, $50. FAF, firearm violations commission only, violations of firearm related rules on conduct, $500. APO, operating outside scope of license. Performing regulated service beyond scope of current license, $5,000. FD, failure to maintain required records, $50. RESOL, residential solicitation violation. Violation of Rule Section 35.10 by company, $500. OOPA, violation. RESOL, residential solicitation violation. Violation of Rule Section 35.10 by individual, $100 per violation. Subchapter E, administrative hearings. Rule Section 35.61, service of notice. A. Licensees shall maintain on file with the department their current mailing and principal place of business address. Notification shall be submitted in writing and received by the department within 14 days of the date of the change of address. B. The department is entitled to rely on the address currently on file for all purposes relating to notification. The failure to maintain a current address with the department is not a defense to any action based on the licensee's failure to respond. C. Service by mail is complete upon deposit of the document enclosed in a postage-paid, properly addressed envelope in a U.S. post office or official depository under the care and control of the U.S. Postal Service. Rule Section 35.62 Default Judgments. Following adequate notice of a hearing on a contested case before failure of the respondent to appear at the time of hearing shall entitle the department to request from the administrative law judge an order dismissing the case from the docket and to informally dispose of the case on a default basis. Rule Section 35.63 Hearing Costs. A. In cases brought before in the event the respondent is adjudicated as being in violation of the Act or this chapter after a trial on the merits, the department has authority to assess the actual costs of the administrative hearing in addition to the penalty imposed. Such costs include, but are not limited to, investigative costs, witness fees, deposition expenses, travel expenses of witnesses, transcription expenses, or any other costs that are necessary for the preparation of the department's case. B. The costs of transcribing the testimony and preparing the record for an appeal by judicial review shall be paid by the respondent. Rule Section 35.64 Preliminary Hearings. A. Preliminary hearings must be requested in writing within 30 calendar days of receipt of the summary action notice letter. 17. B. The appeal of the preliminary hearing determination to must be submitted no later than 15 calendar days following the date of the determination letter. C. Requests for continuance must be submitted in writing at least 3 business days prior to the scheduled hearing. Requests must be based on good cause. Multiple requests may be presumed to lack good cause and may be denied on that basis. 18. Rule Section 35.65 Contested cases based on sex offender registration. Requirements. A. Pursuant to Section 1702.3615 of the Act, in cases in which the Department seeks to deny an application or revoke a license or registration solely on the basis the individual is required to register as a sex offender, the applicant or licensee may waive the right to a hearing before and appeal directly to the board. This hearing before the board is an evidentiary hearing, conducted at one of the board's quarterly public meetings. Such a hearing may be requested by submitting a written request to the department at the address provided on the notice. B. The factors detailed in this subsection may be employed by the department, the administrative law judge, or by the board in cases of direct appeal under Section 1702.3615 of the Act. 1. The age of the applicant or licensee at the time of the offense giving rise to the sex offender registration requirement. 2. The classification of the offense. 3. Evidence of rehabilitation or recidivism. 4. The amount of time that has passed since the commission of the offense. 5. The relationship between the offense and the occupation for which the individual seeks a license, including whether licensure will facilitate the commission of a similar offense, and 6. Any other factors determined to be significant to a particular case. Subchapter F. Commission Security Officers. Rule Section 35.81 Application for a Security Officer Commission. A complete Security Officer Commission application must be submitted on the most current version of the form provided by the department. The application must include 1. The required application fee. 2. Fingerprints in form and manner approved by the department. 3. The required criminal history check fee. 4. A copy of the applicant's Level 2 Certificate of Completion. 5. A copy of the applicant's Level 3 Certificate of Completion. 6. Non-Texas residents must provide a copy of an identification card issued by the state of the applicant's residence, or other government-issued identification card, and 7. Non-United States citizens must submit a copy of their current alien registration card. Non-resident aliens must also submit documents establishing the right to possess firearms under federal law. B. Incomplete applications will not be processed and will be returned for clarification or missing information. Rule Section 35.82 Commission Security Officer Standards. A. Commission security officers shall carry their pocket cards while on duty and when traveling to and from the place of assignment, and shall present the cards upon request by a peace officer or to a representative of the department. B. A commissioned security officer shall not 1. Perform the duties of a commissioned security officer for any persons other than the licensed employer reflected in department records. 2. Possess or use any security officer commission pocket card that has been altered, or 3. Efface or allow improper use of his security officer commission pocket card. C. Commissioned private security officers shall comply with Section 35.14 of this title, relating to security officer uniforms. D. Subsection C of this section does not apply to a personal protection officer while performing personal protection services in plain clothes. 19. Rule Section 35.83 Renewal of Security Officer Commission. A. An application for renewal of a security officer commission may not be submitted more than 90 days prior to expiration. A completed renewal application must be submitted on the most current version of the form provided by the department. The application must include 1. The required renewal application fee. 2. Non-Texas residents must provide a copy of an identification card issued by the state of the applicant's residence, or other government-issued identification card. 3. Non-United States citizens must submit a copy of their current alien registration card. Non-resident aliens must also submit a copy of a current work authorization card and documents establishing the right to possess firearms under federal law. 4. A valid firearms proficiency certificate issued no more than 90 days prior to date of the renewal application. 5. Unless usable prints are on file with the department, fingerprints in a manner approved by the department, and 6. The required criminal history check fee. B. Incomplete applications will not be processed and will be returned for clarification or missing information. Subchapter G. Personal Protection Officers. Rule Section 35.91 Requirements for Personal Protection Endorsement. A. An applicant for personal protection endorsement shall 1. Submit a written application for a personal protection endorsement on a form. Prescribed by the department. 2. Be at least 21 years of age. 3. Either possess a valid security officer commission issued prior to applying for a personal protection endorsement, or submit an application for security officer commission in conjunction with the application for a personal protection endorsement. 4. Submit proof that the applicant has successfully completed the personal protection officer course taught by an approved personal protection officer instructor, and 5. Submit proof of completion of the Minnesota Multiphasic Personality Inventory Test or equivalent, proof of completion of the Minnesota Multiphasic Personality Inventory Test, shall be on the prescribed form declaration of psychological and emotional health, and shall be signed by a licensed psychologist. B. A personal protection officer may transfer his endorsement to another employer if the personal protection officer 1. Has transferred his security officer commission to the new employer, and 2. Submits the appropriate form and transfer fee to the department within 14 days of the transfer of employment to the new employer. Rule Section 35.92 Employer Requirements. Personal protection officer employers shall 1. Issue the personal protection officer endorsement pocket card issued by the department to the personal protection officer. 2. Maintain on file for inspection all contracts for personal protection officer services. And 3. Maintain on file for inspection all current records on all persons issued a personal protection endorsement, including the personal protection officer's name, current residential address and telephone number. Rule Section 35.93 Personal Protection Officer Standards. A. Personal protection officers must comply with all standards and requirements applicable to commissioned security officers, as provided in this chapter and the Act. B. In addition, a personal protection officer shall not 1. Perform personal protection officer duties for any persons other than the person's employer indicated in the department records. 2. Fail to timely surrender the personal protection officer pocket card upon written notice. 20. Served by the department or his employer. 3. While in the course and scope of employment as a personal protection officer, provide or engage in any other service regulated by the Act or this chapter other than providing personal protection from bodily harm to one or more individuals. 4. Fail to conceal a firearm if providing the services as a commissioned personal protection officer in plain clothes. 5. Fail to carry on his or her person the pocket card issued while performing the officer's duties as a personal protection officer. Or 6. Fail to present the pocket card for security officer commission and personal protection endorsement upon request made by a peace officer or representative of the department. Subchapter H. Letters of Authority. Rule Section 35.101 Private Business Letter of Authority. A. The security department of a private business, as defined in the Act, must obtain a letter of authority in order to employ a commissioned security officer. B. A security department of a private business that employs in a non-commissioned capacity an individual meeting the conditions of Section 1702.323d of the Act must obtain a guard company license. C. A security department of a private business shall not provide guard company services to a third party. D. The holder of a private business letter of authority must qualify a manager who meets the requirements of the Act as they pertain to the manager of a security services contractor and maintain on file with the department the name of the individual responsible to ensure the commissioned security officer's compliance and ensure records are maintained in accordance with applicable laws and rules. E. A private business letter of authority is valid for 1 year and may be renewed by submitting the department-approved renewal application and the required renewal fee no earlier than 90 days prior to expiration. Rule Section 35.102 Governmental Letter of Authority. A. A political subdivision that employs a commissioned private security officer must obtain a governmental letter of authority. B. The governmental letter of authority is valid for 1 year and may be renewed by submitting the department-approved renewal application and required renewal fee no earlier than 90 days prior to expiration. C. The holder of the governmental letter of authority must designate and maintain on file with the department the name of the individual responsible for ensuring the commissioned security officer's compliance with the Act and this chapter and for ensuring records are maintained in accordance with this chapter. Subchapter I. Company Records. Rule Section 35.111 Employee Records. Licensees shall keep records of all employees registered or commissioned under the Act. The employee records, detailed in this section, shall be maintained for a period of 2 years from the last date of employment. 1. Full name, date of employment, position, and address. 2. Social security number. 3. Last date of employment. 4. Date and place of birth. 5. 1 color photograph. 21. 6. The results of any drug tests. 7. Documentation of the pre-employment check required under Section 35.3 of this chapter, relating to registration applicant pre-employment check, and 8. All training certificates earned by the employee while employed by the licensee. Rule Section 35.112 Business Records. A. Licensees shall maintain copies of the records detailed in this section, or otherwise required under this chapter, for 2 years from the later of the date the related service was provided or The date the contract was completed. 1. All contracts for regulated service and related documentation reflecting the actual provision of the regulated service, and 2. Copies of any timesheets, invoices, or scheduling records reflecting the employment dates of any registered employees. B. If the company has no physical place of business within the state of Texas, the records shall be maintained 1. At the office of the registered agent within the state of Texas, or 2. At any physical location within the state of Texas of an agent or employee of the company. Rule Section 35.113 Records required on Commission security officers. In addition to any other records required under this chapter, the employer of a Commission security officer shall maintain and make available for inspection the records detailed in this section. 1. The current residential address of the officer as reported by the officer. 2. The current duty assignment and location of assignment. 3. The results of all drug tests administered. And 4. Documented information on all required training obtained by the officer while employed by the licensee. Subchapter J Special Company License Qualifications. Rule Section 35.121 Investigations Company License. A. Pursuant to the Act, the Department has determined that an applicant for licensure as a private investigations company or the prospective manager of the applicant company must meet one of the qualifications detailed in this section. 133. Consecutive years of investigation-related experience. 2. A bachelor's degree in criminal justice or related course of study. 3. A bachelor's degree with 12 months of investigation-related experience. 4. An associate degree in criminal justice or related course of study, with 24 months of investigation-related experience. 5. A specialized course of study directly designed for and related to the private investigation profession taught and presented through affiliation with a 4-year college or university accredited and recognized by the state of Texas. This course of study must be endorsed by the 4-year college or university's Department of Criminal Justice program and included departmental faculty members on its instructional faculty. This course of study must consist of a minimum of 200 instructional hours including coverage of ethics, the Act, and this chapter, or 6. Other combinations of education and investigation-related experience may be substituted for the above at the discretion of the department or its designated representative. B. The degrees referenced in subsection A of this section must be affiliated with a college or university recognized by the Texas Higher Education Coordinating Board, Southern Association of Colleges and Schools, or other accreditation organization recognized by the state of Texas. Rule Section 35.122 Guard Company License. Pursuant to the Act, the Department has determined that an applicant for licensure as a guard company, or the prospective manager of the applicant company must meet the qualifications detailed in this section. 20. 1. Must be at least 21 years of age at the time of application. 2. Must have at least 3 years accumulated employment experience in the field in which the company is licensed, and 3. Must have at least 1 year of experience in a managerial or supervisory position. 20. Rule Section 35.123 Locksmith Company License. Pursuant to the Act, the Department has determined that an applicant for licensure as a locksmith company as owner or the prospective manager of the applicant company must meet one of the qualifications detailed in this section. 1. Qualification Option 1. 2. Consecutive years of full-time locksmith-related experience, or 2. Qualification Option 2. A. Successful completion of a department-approved 48-hour basic locksmith course and a 600-hour Fundamentals of Locksmith course, with the curriculum content detailed in this subparagraph. I. Introduction to Locksmithing. 2. The Act and this chapter. 3. Civ Texas and United States Government Business Requirements. 4. Key blank identification. V. Key machine and key duplication. VI codes and code cutting. 7. Basic lock types. 8. Basic picking. 9. Rim and mortise cylinders. X. Key in knob/key in lever locks. 11. Deadbolts and mortise locks. 12. Installations. 13. Impressioning. 14. Basic master keying. 15. Basic safe servicing. 16. Small format interchangeable core. 17. High security and key control cylinders. 18. Automotive opening. 19. Automotive key generation and programming. 20. Exit/panic device servicing, replacement, and installation. 21. Door closers servicing, replacement, and installation. 22. Cabinet and drawer lock servicing, replacement, and installation. 23. Safe installation, moving, and anchoring. 24. Single door access control service and installation. B. Successful completion of a basic locksmith proficiency exam that covers a minimum of 12 locksmith subjects and is approved by the department, and C. 1 year of full-time locksmith-related experience. Subchapter K. Fees. Rules Section 35.131 Licensing and Examination Fees. A. Pursuant to the Act, below is the fee schedule. Class A license, original and renewal, $350. Class B license, original and renewal, $400. Class C license, original and renewal, $540. Class T license, original and renewal, $2,500. Assignment of license $150. 21. Branch office certificate and renewal $300. Change name of license $75. Delinquency fee, post-expiration renewal penalty, $30. Duplicate pocket card $10. Employee information update fee $15. Criminal history check fee $31.50. Letter of authority fee for private business $400. Letter of authority renewal fee for private business and political subdivision $225. Manager re-examination $100. Personal protection officer endorsement $50. Preliminary criminal history check and evaluation letter $100. Pocket card endorsement, add or delete, $20. Reinstate suspended company license $150. Registration fee for alarm systems monitor $30. Registration fee for dog trainer $30. Registration fee for employee of license holder $30. Registration fee for non-commissioned security officer, original and renewal $30. Registration fee for owner, officer, partner, or shareholder of a license holder $50. Registration fee for private investigator, manager, branch office manager, locksmith, electronic access control device installer, and alarm systems installer, original and renewal $30. Registration fee for security consultant $30. Registration fee for security salesperson $30. School instructor fee, original and renewal, $100. Security officer commission fee, original and renewal $50. Training school and continuing education, CE, school approval fee, original and renewal, $350. B. Upon completion of development and production of the department's new laminated pocket card, an additional fee of $5 will be charged for any new application or renewal requiring the new card. C. Fees collected are non-refundable and non-transferable. D. Payment of fees shall be made in a manner approved by the department. E. If payment is dishonored or reversed prior to issuance, the application will be abandoned as 22. Incomplete. If the registration, endorsement, commission, or license has been issued prior to being dishonored or reversed, revocation proceedings will be initiated pursuant to the Act. Section 1702.361. The Department may dismiss a pending revocation proceeding upon receipt of payment of the full amount due, including any additional processing